Hello, I'm Chris Mason, Associate Director at MKB Law. I'm joined today by Gordon McElroy, Managing Director of MKB Law, and we're going to be discussing shareholder disputes.
Yeah, morning, Chris. I suppose my first comment about shareholder disputes is they're best avoided.
Absolutely.
And I know we'll get into the meat of it in a moment or two, but if people come early, we have solutions to the problems. So if people signed up to shareholder agreements and a good set of articles of association that will deal with the governance of their companies, they're not going to move into your world where they have a shareholder dispute.
Yes.
So really what we're talking about is those people who haven't had the foresight to do those things, and they're left with the model articles and the Companies Act, and they're coming to you and they're saying, "Oh, Chris, I've got a problem. What can I do about it?"
Yeah, and I think the key thing is, what we do is primarily dispute resolution. So we have to assess whether there actually is a dispute or whether this is a disagreement in a vacuum or a storm in a teacup. And if it's not that, then, as you say, we need to look at what's in their toolbox to help them resolve the dispute.
And that's a very good point, because often they're driven by personalities.
Absolutely.
And I think you find in Northern Ireland, because companies tend to be smaller, that they are the quasi-partnership type companies, which obviously have remedies that are very specific to them, but they are quasi-partnership, and it has often been a journey where people have a company that they've set up. It has been successful, it has done well, but for some reason, which may be marriage difficulties, it may be generational change, it may be just the two shareholders can't stand the sight of each other anymore, it is no longer working.
Yes.
So let's say I were to come to you and I'm a 40% shareholder in a company and I'm complaining that I've been excluded from the decision-making processes. What does the law offer me?
So if you had a 40% shareholding, you would be a minority shareholder. Obviously, minority shareholding by its very nature can be a vulnerable position. You lack the voting power on your own to influence decisions. And if you feel that you are being treated unfairly by the balance of the shareholding, being 60% in your example, then I suppose the primary remedy, if we were looking at it from a litigation point of view, would be unfair prejudice petition. I think before we would get to that point, though, we would be looking at whether there are any mechanisms in a shareholders agreement, if you have one, to try and ease the dispute before it gets litigious. But certainly the primary remedy in litigation terms would be an unfair prejudice petition.
I'm old enough that we used to call it oppression of the minority, which I thought was a lovely expression.
Absolutely.
But we have moved on to unfairness and prejudice. Can you give a few examples of things that are unfair or prejudicial? It has to hit both tests, doesn't it? It has to be unfair and prejudicial.
Yeah. So primarily you would be saying that the majority is acting in a way that unfairly prejudices your interests. An example would be being excluded from decision making. So as a 40% shareholder, that's still a significant shareholding, but because it's less than 50%, you could still be pushed out or sidelined when it comes to decision making. You might not receive dividends, or you might not receive
That's a
fair dividend.
Problem, yeah.
Or there's also the possibility of your shareholding being diluted by, for example, the majority deciding to allot more shares or issue more share capital to others. Other examples would be lack of access to information.
And I think where I have seen it over the years, that lack of access to information has often been the trigger and has been one of the more difficult situations, particularly where you have somebody who has been a passive member of the company for quite a long time and then starts to become irritated or annoyed about their other shareholders' behaviour.
Yes, things happen over a long period of time and the minority or silent shareholder is either comfortable or disassociated with how things are happening, and then all of a sudden realise something's changed, or whether it's a change in how the company is operating, the dividends that they might be receiving, or a change in their own personal circumstances, so that actually they need to try and extract more value from their shareholding. and they suddenly request a lot of information which might not be forthcoming.
Yeah, and that can be because of natural changes. Somebody's getting older. They may be at the point in life where they're saying, I want to extract my value from this business, but the other shareholder doesn't want to extract value, wants to keep the business going, and people want to go their own separate ways.
Exactly.
So say I'm in that place and I've come to you, I've got my 40% shareholding, I'm unhappy with the way the business is going, I'm thinking that the majority shareholder is excluding me from decision making, not giving me the information that I need. How do you kick off the process?
So we would, once we'd taken full instructions and had all the information, we would write a fairly detailed letter to the other shareholders, pre-action protocol letter we would call it, and it would set out the full factual and legal basis for the complaint that you had about feeling unfairly prejudiced. That letter would set out what proceedings we intend to bring if we have to get to that stage, but it would also be inviting them to engage in alternative dispute resolution at an early stage, just to try and break the dispute and obviously stop costs escalating.
Yes, and if they're clever, if they're proactive, they'll come forward quite quickly with a solution or a proposal to say either they will buy me out or I will buy them out if we can agree a valuation. Do you see that happening in practice?
Where the company is not as closely held as some might be. So what I mean by that is a lot of disputes involve relations who are co-shareholders, and actually the dispute is not primarily about the company. It's about something else in their private lives, which they twist into a commercial dispute so that they can have some kind of formal process. Those ones tend to be tricky because actually a resolution to the commercial dispute isn't the primary objective.
Well, isn't that often the case? People are seeking solutions that the law can't offer them, which is, I know it's a different subject, but it's a great reason for mediation, and maybe that's something we can talk about another day.
Yes, no, absolutely. And I think the other time that resolution can be more difficult is if you're dealing with the executor of a shareholder's estate. So the shares have obviously passed on the shareholder's death, and perhaps that person doesn't have the knowledge of the company that they ought to have, or wants something in consideration of the shareholding which isn't immediately achievable. But otherwise, yes, it's business is all about being commercially astute, and settlement of a dispute quickly is the commercially astute thing to do where possible.
And if that fails, then you go to court?
Yes, you would issue an unfair prejudice petition, in which effectively you would be asking the court to make a decision as to whether the majority shareholders should buy out the minority shareholding, or in more extreme cases whether or not the company should be wound up.
And that can be on the just and equitable ground.
Just and equitable
grounds.
Yeah.
But that's the nuclear option?
It is, because I think ultimately nobody wants to see a company fail for reasons that it doesn't have to, if that makes sense. If a company has legitimate financial pressures and cannot continue to trade solvently, that's one thing. But a company failing and dying because the shareholders can't agree on something is actually a bit tragic.
Yes, I think where I have seen the just and equitable option being most effective is for investment companies, where the underlying assets are assets that can be realised and distributed. It's almost always very tax inefficient for the parties involved, but you're much less likely to see it with a trading company where you have employees and other stakeholders apart from the shareholders. It's a devastating course of action for them.
Absolutely. And that's why we always push for alternative methods of resolution. Mediation, which you mentioned, is really effective because there is an independent, neutral third party who's qualified to offer views and opinions on the subject matter, but is not vested in any way, and they can privately speak to each side and press upon the points that perhaps might be weaker.
Chris, we've been to court. We've got the order that the majority shareholder has to buy me out as a 40% shareholder. Am I going to lose out substantially on the value of the assets in the company because I only have a minority shareholding? Is there a discount that has to be applied?
So in a quasi-partnership situation, which the majority of shareholders' disputes would be, there wouldn't be any discount applied to the minority shareholding.
Oh, okay, that's encouraging.
Obviously, there's information that would be presented to the court about what the value of the shares are on a full market basis, and that's what we would be aiming to achieve.
And the other situation, of course, could be where I represent shareholders and we're really unhappy with the way the directors have been running this company. We think the directors have done anything that might have cost us money. They've entered into a bad deal, or they've been guilty of bribery and the company has ended up being fined. Have any remedy against the directors?
Yes, so you can bring what's called a derivative action, which in simple terms is a lawsuit brought by shareholders on behalf of the company. It's typically against the directors or other shareholders for whatever you perceive the wrongs to be.
I can take action directly against the directors. Yes.
You can, in the name of the company. So some examples would be if there's been a fraud or breach of directors' fiduciary duties, negligence by the directors, anything that you consider harms the company can be brought as an action.
It's a complex area. Is it continuing to evolve? Are there new trends emerging that you've seen?
I think there definitely are trends and developments in terms of how these disputes are going. A couple that are interesting is post-Brexit uncertainty. So obviously the economic uncertainty that's been brought about by Brexit is fairly mainstream in the media. So how that impacts on the financial bottom line for the shareholders is leading to heightened tensions amongst shareholders. There might be disagreements about how to navigate the post-Brexit challenges, or about perhaps whether the future focus of the company should be in order to thrive in that environment.
And I could imagine moving towards ESG policies is creating a little bit of friction between some shareholders. And
ESG is becoming again a mainstream talking point in companies. Companies are increasingly being expected to account for their sustainability as well as their profit-making potential. And some shareholders naturally will care more about making money, whereas some will care more about the long-term sustainability and how the company will be perceived on the basis of its sustainability objectives.
And that's entirely natural within the sort of family companies we have in Northern Ireland, where age has a huge impact on whether you're interested in short-term returns or long-term returns.
Absolutely. And there's a phrase that keeps coming up, activist shareholders, which would tend to be the younger generation who expect to see and prioritise sustainability and environmental impact sometimes more than profit. And obviously for differences of opinion in that area, that can lead to fairly severe conflict.
Yeah. Okay. Chris, that's been really useful. Thanks a million. And we'll pick up on the mediation.
We will, yes, absolutely. Thanks, Gordon.